to the KJ Methods YouTube channel. Don't forget to like, subscribe, and share this video. What I want to talk about today is these contract terms, rescission versus breach. As you know, for the state exam, you need to be very proficient in contracts. And the contracts chapter is not very difficult, but there are some confusing concepts in there. Now with these two, students don't even know that they are confusing these concepts. But boy, does it get underneath my skin that students will call what is a breach a rescission. So let's talk about them. What I want you to understand is that a rescission and a breach cannot live in the same sentence. In other words, rescission is a right that the law gives you to get out of a situation. We've seen it many times under the national law. Voidable contracts, you have a right to rescind. And then we have other contingency clauses, right? Let's say you have a finance contingency. You have a right to rescind if you don't get the financing. How about due diligence? You have a right to rescind during the due diligence period. Lead-based paint, you have a right to rescind in that period of time. And so a right to rescind is potentially a good thing. In this sense, if you're operating under a right to rescind, you can simply say, I want to get out of it. I don't want to be in this contract any longer, and the person cannot hold back any of your money at all. So what you gave to them, let's say you gave earnest money of $5,000, they have to give you all of the earnest money back because you're under a rescission right. A breach is something totally different. A breach means that you're not doing something in the manner that you're supposed to be doing it. In other words, you have broken a promise of the contract. And so in that regard, a breach potentially means you're going to lose your earnest money or you're going to lose something relating to that contract. Two totally different things. Rescission, good. Breach, bad. We can look at certain rights that a person would have if a contract is broken. If a contract is broken, you remember, you could sue for damages. If a contract is broken, you can sue for specific performance. But understand, you can only sue for these things if the person has breached the contract, not if they're utilizing a rescission right. Because if they're under a right to rescind, then there is going to be no lawsuit because they are exercising the right that the law gives them. The last thing I want you to understand is you do not have a rescission right in all circumstances. There are very limited circumstances where the court would give you a rescission right. And so if you enter into a contract, you simply don't like the terms of the contract and you decide to walk away, that is a breach, not under your right to rescind. Well, that's it for today. Another short video just clearing up some confusion. Once again, don't forget to like and subscribe and share the videos with your friends. Thank you very much for coming to the KJ Methods YouTube channel.